Good afternoon and welcome to the second episode of season 2 of Have We Got Planning News for You. We hope you've had a great week so far with all this lovely sunshine. Thank you for joining us and resisting the temptation to head outside. Can I start with my usual reminders to you? Firstly, to consider making a charity donation to the NHS Combined Charities Just Giving page, your local charity of your choice. That is, after all, what brought us here in the first place. And secondly, please do keep the questions and banter flowing in the Q&A box. As I said last week, we'll be selecting at least one audience question every episode to put to our special guest. It's my duty this week to ask Simon one of your questions. And on the subject special guests, we welcome back today to the show Simon Gallagher, MHCLG's Director of Planning, and our first repeat guest. Simon, welcome, and thank you for coming back and joining us once again. We obviously didn't scare you too much last time.
Thank you for having me back. I think that was the sound of the barrel being scraped, and I am that barrel being scraped. I know my place.
Not at all. Now, Simon, tell us where you are, what you're drinking. I see this time, for avid viewers, you have got something that's enables you to open your drink, and tell us what you've chosen for this week's theme and why.
So I am in a loft room in South London enjoying the glorious sunshine. And what I have here for my drink of the day with bottle opener, and I don't know whether you can see this, is a German black beer called Köstritzer. And it's beautiful stuff. It comes from a place called Bad Köstritz in East Germany. And it's lovely. And it's partly, this is my theme for the day, is Germany. Now, some of you will know this is not just an excuse for me to drink in public, although I don't need much of one of those. But I spent 4 years working for the government in the embassy in Berlin. And so Germany is something that's just quite dear to me. And so it is a connection between alcohol and this. And also, there is a bit, which is quite a lot of our planning white paper, has a lot of connections with the German planning system. So I think there's a lot of connection. And I'm looking forward to a fact-finding tradition on how breweries get permission.
Fantastic. We look forward to hearing more about that later on. Cheers. Simon. If it's a super strong German beer, then drink it all before we ask you the questions. Then we'll go to tease extra information out of you that we didn't think otherwise. And that's not the reason why we'll be interviewing in the second half of the show, because as you know, and as everyone knows, that's how we play it. So we'll be interviewing Simon in the second half. Looking forward to discussing some more details of the planning white paper with your good self. Chris will be leading the interview, and Chris has promised not to ask more than 94 questions.
On the standard method.
Now, it's time to introduce the regular panel. So, starting with Mary, as usual, tell us who you are, where you're calling from, what you're drinking, and anything else you'd like to tell us about.
Well, hello, everybody. My name's Mary Cook. I'm in the offices at Town Legal in the city, and my particular contribution with regard to Germany is really just to tell you that I was actually born in Germany. I was born in West Germany, and I lived there for the first 4.5 years of my formative life. And I came out of Germany loving German salami, but sadly I couldn't get my hands on German salami, and I'm secretly drinking my usual gin, I have to go. But don't tell the others in the office.
I didn't think... Now, before we go to Chris, we should say, inform viewers, that Chris has shaved off his handlebar tash beard after his application to join the Hells Angels was rejected.
Yes, well, that's absolutely right, Charlie. The beard went. Apparently, it wasn't that popular in some quarters. So I listened to advice. Yes, I'm back in inquiries, in virtual inquiries. I'm here in the marketing suite of number 5, as you know. And I've got a German beer kindly brought to me by my junior, Oliver Lawrence, who's been out, and his instructions this afternoon were to get some German beer. He's succeeded in that task. And I've had a busy week, mostly cross-examining about landscape. Yes, cross-examining about landscape. Imagine that.
Your bottle looks very big.
It is very big. Thank you, Mary.
Good evening, Charlie and everybody, and hello, Simon. I'm Paul Tucker. I'm from King's Chambers. You will have heard the music from my son's band to start off with. That's the Ruby Tuesdays, and you'll see behind my son's band name here. That's because I've been relegated to his bedroom because my next door neighbour is taking render off the side of his house, so my office is unusable. So that's the gold disc that he wants to have if anybody logs on Spotify. I'm drinking Budweiser, which is thought to be a Czech beer. But of course, Simon will know, notwithstanding the shaking of his head, it was in fact invented by a German called Adolphus Busch, who brought it to the United States. And not only do I have one talented son, I have three talented sons. My youngest son is very into flags. So I set Simon a task, which is, which flag is this, Simon?
Oh.
Well, I can proudly announce that my Googling skills are not quite good enough.
Bavaria, Prussia.
So this is the former flag of the Austro-Hungarian Empire.
Ah.
Oh,
And
wow.
you've got to ask yourself, why on earth is it in my house?
Yep.
That's a whole story altogether. Sasha, good afternoon. How are you?
I'm very well, thank you very much. Yeah, cheers, Sarajevo, 1914. Great flag, Paul. And also, I'm going to out you. Don't give us that nonsense about your neighbour's render, because when I came to your house, the nearest property was about 2 miles away. Right, I'm in London. I'm very near to Mary. I'm in the City of London. I'm in my bespoke suite of landmark chambers, and I'm drinking because in the era I'm representing Simon's bosses, and in the era of Brexit, I'm drinking an English cup of PG Tips.
Well, and I'm Charlie Banner. I'm also in London, in my chambers, Keating Chambers on Essex Street. I am drinking Beck's. In a break with tradition, and because for a while this afternoon I couldn't find a German beer, I couldn't find salami either, so I found a German chocolate, which actually, given that the Germans, it must be said, I think it's probably fair to say they're not renowned for tasty food, in my own view anyway.
Oh, speak for yourself.
That's a slander.
Absolutely.
I must also tell you that this, before we get to the serious stuff, that I'm a little bit worried about what this German theme today will do to the targeted advertising I receive. And some of you might know already, after having been to see Bon Jovi and Def Leppard co-headline a rock concert at the Munich Olympic Stadium last July, I've been bombarded with targeted advertising on Facebook for a range of different kinds of lederhosen. I promise you, I haven't bought any of it.
I've seen you wearing it.
Yeah, stand up, Charlie.
That is an absolute lie. On to some serious stuff. From lederhosen to Section 106 agreements. What a segue that is. Our court case is Norfolk Homes and North Norfolk District Council, a recent judgment by Mr. Justice Holgate. Great victory for my good friends Christopher Lockhart Murray, CLM. This was a case about the dry but commercially very important, dare I say increasingly important topic of how Section 106 agreements and undertakings are to be interpreted. And in particular, whether in the absence of a deed of variation, they apply to a subsequent varied planning permission under Section 73 of the Town and Country Planning Act. The basic facts were that a Section 106 agreement was entered into in 2012, including various affordable housing obligations, in connection with the planning permission granted by Norfolk Council to Norfolk Homes for an 85-dwelling development. What happened next was that two subsequent permissions were granted under Section 73 in 2015 and 2018 with varied conditions. But for whatever reason, I suspect a cock-up, the council didn't require a new Section 106 agreement or a deed of variation applying the old one to either or both of these permissions. The obligation of the 2012 agreement were expressed to come into force in relation to the implementation of the development, which unsurprisingly enough was defined as the development permitted under the 2012 permission, which then expired unimplemented. And the council argued that this definition should be interpreted as including any subsequent variations to the 2012 permission, or alternatively that an implied term should be read in to the same effect, namely that the agreement applied to Section 73 permissions that might come subsequently. And Mr. Justice Holgate had none of it, quite rightly, if I may say so. In my view, it's a complete try-on, which flew completely in the face of the contractual wording. The judgment contains an important explanation of the principles applying to Section 106 agreements and in their interpretation interpretation, including justice in relation to ordinary contractual documents. The express wording is critical, of course. The court will interpret that wording objectively, not by reference to what the parties say they meant or intended, and not with the benefit of hindsight. And the court will be very slow indeed to imply wording into a Section 106 agreement beyond the explicit wording used, even slower than in relation to ordinary contractual documents. Great restraint, as Mr. Justice Holgate put it, would be applied to any suggestion of reading terms in, implying terms. He said the courts mustn't fashion and impose an implied term to reflect the merits of the situation as they now appear with the benefit of hindsight. And he went on to say there's no general anti-avoidance principle whereby Section 106 obligations should be read so as to prevent landowners and developers from getting out of obligations, or to make up for local authorities not including terms which they later wish they had done in order to avoid any loopholes. So the headline really is parties to a Section 106 agreement, and I think this applies to options too, should expect to be bound by the terms of the words they sign up to. And if that proves to be a bad deal for one of them, for example, even if the LPA feels subsequently that it means the developer gets off the hook for contributions that they could have been required had the agreement been better drafted, that's tough luck. It's not for the court to rescue a party to a contract from having screwed up. And I'd suggest that's a victory for legal rigour. It would have been a real blow for the certainty and predictability of 106 agreements had the court bowed to pressure, as I suspect some judges might, to bend the wording in order to avoid a harsh outcome for the LPA and in order to avoid the developer escaping any obligation to provide affordable housing. Finally, so this is highly topical. Personally, I'm seeing an awful lot of questions being asked at the moment about the interpretation of Section 106s and option agreements. I've done no fewer than eight opinions this week. I'm almost cross-eyed as a result, and a number of those have been on those kinds of issues, possibly reflecting the current economic climate. And I think it will be relevant post the white paper reforms, assuming they are enacted, because even if there's no new Section 106s, the existing ones will remain in force. So there we are, Section 106 agreements. Thrilling. Mary, any thoughts on that yourself?
I've got a couple of observations. First of all, it's interesting to note that this was a Part 8 claim in the Queen's Bench division, and that they recruited Holgate into the QB division in order to hear the case. And also, to be fair to Estelle de Hon, who was, shout out for her, who was acting for the council here, Lockhart Mummery's attempt to knock her out at the summary stage failed, and it went to full trial. So she did give him a run for her money. I think the moral of this is that in the 21st century, surely everyone should be looking at extended definitions in Section 106 obligations so as to include Section 73 applications that come along subsequently. And all local authorities on a Section 73 application should be making sure that in the absence of such a clause, there is a deed of variation entered into so as to bind the earlier 106.
Thanks, Mary. From Section 106 to another High Court case, Sasha, you're going to tell us about the Gathercole case.
I am, which is a lead judgment of Lord Justice Coulson, ex-member of Keating Chambers, and give a shout out to Tom Coulson as well. But this is a case in relation to public sector equality duty, which we all know is taking increasingly important role in planning inquiries. Indeed, I've got one in a couple of weeks where the sole reason of refusal of the LPA relates to an alleged breach of the public sector equality duty if planning permission is granted. So look out for that. Now, this was a judgment which was in Suffolk, Levenheath. It related to the new school, significant housing in Levenheath, and it related to a new primary school and whether in granting consent the council had taken into account the public sector equality duty. And we must remember the law imposes a requirement to have due regard to the need to do various things, which can be all termed and badged in the public sector equality duty. And what is interesting about this decision, that I would suggest anyone involved in a case that has the public sector equality duty to have a look at it, because it does two things. It sets out the law, and it also sets out the cases which have dealt with that. I think the standout points are that the court found there was a breach of the public sector equality duty, which is quite noteworthy, but, and particularly to our planners amongst us, I must identify Section 31(2)(a) of the Senior Courts Act, which states in terms that if it appears to the court to be highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. Now, let's remember, in the auspices of a JR, which of course is always the process for challenging the grant of consent, it is discretionary, and the powers within section 31(2)A are open to the court to exercise. In this case, whilst finding a breach of the public sector equality duty, the court was absolutely certain that even if the public sector equality duty had been complied with and fully taken into account in the decision, effectively the planning judgment of the committee would have been the same. And on that basis, the court decided to withhold a quashing of the decision, exercise its discretion in favour of the respondent. So I think this is a really interesting case in relation to the application of public sector equality duty, which my judgment is, I don't know if you share it, but is becoming increasingly important in planning and increasingly utilised by local authorities and objectors in the planning process.
Yeah, agreed. Sasha, Paul, what do you think?
I agree with every word that Sasha's just said, but I have to say that part of the joy of this this game is to read really cracking opening lines in judgments. Lord Denning used to come up with a few, but Lord Justice Coulson has come up with a couple of crackers on this. I'm hoping that I've successfully screen shared, but
you have.
And it's highlighted. Let me just read you the start of this, because I want to do it in the voice of an old man, as if it's the crusty judge, but I can't do that. It says,
wonderful, actually. I think, isn't it, Lord Justice Coulson?
It says, the right of an aggrieved party to seek judicial review is an important safeguard to prevent capricious or irrational decision-making. Quite right. Too often, however, he said, such challenges can depart radically from the original planning objections and focus instead on what might be called generic failures to comply with statutory obligations which have never before been raised. Two regular candidates, he says, for such after-the-event challenges are the planning authority's alleged failure to have regard to the public sector equality duty and the failure to require a proper ES. Sometimes, and this is the killer, these kinds of challenge can take on an arid quality, raising matters of form rather than substance. This is a bit of a kicking for the claimants, or the appellants in that case. It's really saying, yes, you can think of some clever arguments, yes, you might win, but the courts aren't going to be particularly sympathetic for points that haven't been raised before and which really go nowhere. Well done to Lord Justice Coulson.
Yes, and I think it might well be a point taken up by Lord Fawkes.
It is, yeah.
Totally agree. Actually, as it happened, to be fair to our few Northern Irish viewers, the Northern Irish court said something very similar about 5 years ago in a case called Newry Chamber of Commerce, worth looking at if ever you want to take a point like this. Now, we're going to move to a planning appeal decision, Oldbourne. In a break with the tradition of season one, we're not going to ask Paul to talk about Chris's victories, or indeed Chris to talk about Paul's victories. Mary is going to lead instead. So tell us about Christina Downs' decision in Oldbourne.
Yes, thank you very much. So this was a case, our regular viewers may recall a scene on a beach on the Isles of Scilly where Chris was trying to impersonate John Cleese, and he was perhaps impersonating John Cleese. And at the time, he just finished his closing submissions, as I recall, in relation to the case. So this was about 85 C2 units on a site outside the defined built-up area boundary, and so in the countryside for planning policy purposes. And the appellants tried to argue that paragraph 11 and the presumption in favour of sustainable development was engaged for two reasons. Firstly, they said that the local plan policies were not up to date. And secondly, they said the basket of the most relevant policies were not up to date because they were inconsistent with the NPPF. And in a nutshell, both of those arguments failed. And I would suggest that those interested look at this decision, because it's actually a textbook application, I would say, of these issues, and in particular the point about whether the development plan as a whole was up to date or not. And what Christina Downs in this decision does is look at it very clearly, and then goes on to identify the most important policies. She looks at whether those policies are up to date, and she then looked at the effect of this development on the character and appearance of the area, and she said there would be relatively small harm which would reduce over time. She looked at the visual effects. She said they'd be limited and localized. She looked on the character of the settlement, and she said there would be little harm, no unacceptable loss of high agricultural value. There were 4 grade 2 buildings, and there was also a local heritage asset. She said there was lower than moderate harm in some cases, relatively small amounts of harm in others, and the undesignated heritage asset had a very small degree of harm. Very precise analysis, very precise conclusions. She then looked at the relative sustainability or otherwise of this village in West Sussex, and decided that really the appellant had done all that they could to reasonably enhance accessibility. And I gather there was a not-for-profit minibus for staff in the 106 obligation. She identified that there was a need for extra care provision. There was an absence of an allocated DPDs. There were no allocations here. This is a very important point. There were no allocations in a development plan document that the council could point to meet the need that Chris's clients demonstrated. She gave substantial weight to the provision of these C2 units. She also agreed that they'd free up family housing, and she gave that benefit significant weight. So overall, she gave the social and economic benefits significant weight. And although it was contrary to the development plan, the social and economic benefits were material considerations which indicated that planning permission should nevertheless be granted. So applying an ordinary planning balance, Chris won the day. So well done to him and his team. And this was a Barton Wilmore, Guy Flintoff and Lucy Wilford. Hello, Lucy. First met you years ago. Victory. Well done.
Hello, Chris. So tell us your take on the case.
Okay, well, it wasn't me, it was my team. But Mary is absolutely right. This is a case where, and we should see more of this in my opinion, you are contrary to the development plan. Sometimes that plan's out of date, but in this case, Mid Sussex had a part 1 plan, but didn't have a part 2. But material considerations outweighed it. You know, there's a housing crisis. Now, how does extra care fit into that? Well, my own view is extra care is the sleeping giant of housing provision, because in the United States, 17% of the over 65s live in specialist retirement accommodation, and in Australia it's 13%. You can tell I was doing an inquiry on this, can't you? And in the UK it's 1%. And the benefit of this is not only that it provides suitable housing for people of that age group, but it also frees up lots of family housing. We've all got relatives who would be better located in this kind of development. Now, Simon, just while you're there, it would be right to say that the guidance on this, there is guidance, the government's recognised it in the PPG and has identified a need to look at specialist accommodation for the elderly, but the guidance doesn't set any kind of level, which is all the problems we had with OAN before in respect of housing. And we just need clarity, something like a particular level to help this sector grow and to free up lots of family housing. Okay, that's the end of the advert. Two things I just want to say finally, all right, is to mention two fantastic women. The first is the inspector. Now, I need to be very careful. When you win a case and then you compliment the inspector, you need to be very careful about that. But I can do it in this case because I'm talking about two cases, actually, with this inspector, Christina Downs. One I won and one I lost. Okay, and I lost to a certain gentleman called Sasha White, which was painful, obviously, very painful. But he won a case earlier this year. But Sasha would agree with me, I'm sure, with a thumbs up, that this inspector takes a completely thorough and comprehensive approach. So even though we had roundtable sessions on landscape in Sasha's case and in this one, they lasted a day. The inquiry, if you look at the decision, lasted 9 days. It carried on, as Mary said, into my holidays in Tresco. I was only too happy to continue and finish the case. But, you know, a round table on landscape that's done in half an hour isn't a proper consideration of the evidence. If we're going to have round tables, let's have proper detailed examination of that evidence, which is exactly what this inspector does. So you have complete confidence in the system. The previous inspector who looked at it started the case and then we had COVID. So, well, Mr. Young, you can continue, but you need to finish in 4 days. And my judgment was we wouldn't finish in 4 days and we wouldn't do justice to the case and the need case. So we ran a case for 9 days and was successful. And I think that's really important. The other person I want to mention, Mary has already done it, is Lucy Wilford. Now, Lucy Wilford, well, forgive me for saying this, she hadn't given evidence at an inquiry before, but she was absolutely brilliant as the planning consultant in this case. The client had confidence in her. And here we have a relatively young female planning consultant giving evidence and being at the centre of the whole case, and a client who firmly believed that Lucy would do a good job, and she did do a brilliant job. So let's see more clients and let's see more male directors championing female planners, not even at director level, and saying, you give the evidence. Lucy Wilford, you nailed it.
Fantastic, Chris. I couldn't agree with you more about Christine Dagger. One thing that she does particularly well, which a number of inspectors do, but some perhaps a little bit more nervous about, is express an inclination. You know, she'll ask a lot of questions. She's not afraid to put her cards on the table. That there certainly used to be a concern amongst some inspectors, if they asked questions, they kind of revealed anything about how they were thinking, that would give the perception that they were biased. It could be seen as being unfair. It's far more unfair to have a thought and not reveal it, and not allow the advocates and the witnesses to persuade you by actually saying, look, I think this point's a bad one. What do you say about that, Mr. Young? Far more fair to give you that opportunity to persuade. Now we must move on. Paul, you're going to tell us about the Highthorn case, which has come back again. You're on mute. That sounds a lot better. It's a great improvement.
I love you, Charlie. I hope you know that. Right, this is a decision of the Secretary of State from the 8th of September on an application which was submitted 5 years ago on the 12th of October. 2015. It was called in the following year, 2016, and the first decision was issued in November 2018, and it's a redetermination based upon a recommendation of the inspector I spent all week in front of, John Woolcock, also an excellent inspector, and that's not just because he's not yet determined the appeal that I'm in front of him on, but I do like him, he's great. It's a minerals case. It ultimately proposed just shy of 3 million tonnes of coal extracted from by surface mining. And I should, just as an aside, say that my grandfather, my maternal grandfather, when he took me to Cambridge for a law degree, did point out to me that his advice to me was, whatever you did, lad, don't go down the pit. So good advice to a prospective Cambridge undergraduate, I felt, and I followed that advice firmly.
So northern, so northern.
I didn't get the same advice.
Right, so the variety of issues in terms of adverse effects in this case: landscape, visual issue, there was ecology issues where there was a benefit. There was also the impact upon the setting of a scheduled ancient monument, and also the impact upon a non-designated heritage asset, which is a pillbox in Drawridge Bay, which I've actually stood in. Amazing place, which has subsequently been listed, interestingly enough. But the application was considered contrary to the minerals plan and was contrary to the local plan, because it was in an area of high landscape value, both of which required exceptional circumstances before it came forward. But the Secretary of State interestingly concluded that those policies were out of date, and therefore paragraph 11D was engaged. So this is a case where you had to grant permission unless there were significant adverse effects. Well, greenhouse gases, which have been the subject of the High Court litigation, were found to be neutral in broad terms. So the issue really turned upon the benefits of coal. And for somebody such as myself, who was brought up at a time when we had the miners' strike and the importance of coal throughout the north of England, the South Wales, the Nottinghamshire coal pits, it really is interesting to see that this was in part a decision based upon the fact that only 10% of the coal was going to go to energy and gas-fired power coal-fired power stations. Most of it was going to go to the domestic market, but there were very few contracts that were identified. And the government is looking to phase out the use of coal for energy generation by 2025. And in this instance, therefore, the adverse effects outweighed the benefits arising from coal mining, and also the fact that NPPF had changed the weight to be given to those benefits. It's a real sort of end of an era case, I think. It's a real case where I think we're going to see very few more coal proposals, if at all. So relish it, but it's interesting that it was a dismissal notwithstanding the engagement of the presumption. Thank you, Charlie.
Thanks, Paul. Sash?
Yeah, very quickly, I'm conscious of the time. I just wanted to make, rather than a substance point, a process point. And as we've got Simon here, I think there's a slight problem with Section 77's redetermination, and it's noteworthy this was done by written reps, as I understand it. You can tell that because the appellant's advocate was Mrs. Justice Leven.
Yeah.
So I just think, and I've got this, obviously, I don't want Simon to run off screaming, but I'll mention this in the context of West Ferry, where the council, sorry, how to determine West Ferry. No, I just think there's a serious point about maybe looking at criteria or giving a bit more indication about what will be determined on after quashing by written reps, public inquiry or hearing, etc., because it's noteworthy for a scheme of this scale that all the parties obviously agreed in the light of the inspectorate's decision to determine it by written reps after the quashing. And I think that is an interesting area. So that was my take out from that it was determined by written reps, as I understand it, subsequently.
Thanks, Sasha. Well, I'll hand over at this point to Chris to start the interview with Simon. Final call for any questions. Now, we've got some really good questions. I'm going to have to, quite a tough choice between them, but final call for any questions from the audience. Over to you, Chris.
Thank you very much, Charlie. Well, Simon, welcome again. We are really delighted to have you on the show, and it's probably been quite a busy time for you up to now, has it? I don't know if you had much on.
Yeah, it's been quite a few months, but look, seriously, actually, although I've had a busy few months and the team have done heroics, actually there are others who are responding to COVID at the moment who've had a slightly busier time of it.
Yes, okay, well, I completely understand that. There was a very significant compliment for all the civil servants, both from Chris Kitkowski on the special edition, noting that none of you get mentioned, but you all work as hard as all the people who did get mentioned, if not harder, and indeed from Joanna last week. So I think we all need to recognise just the enormous work that the civil service does, and you don't get any praise, but I'm giving you a bit of praise now, okay? Now, obviously,
your inquiry tactic to butter them up before coming in with that.
Yeah.
1000%.
Yeah.
Don't fall for it, Simon.
Yeah, they know me. Okay, now, look, absolutely clear. We have got two documents that you are consulting on, and I just wanted to make a very clear visual point. We've got two consultation exercises, and they have different end dates. And the end date that's most pressing is the one on the changes to the current system. That's right, that ends on the 1st of October. And so I'm deliberately going to ask you some questions about that first, and then we're going to move to the white paper, and all the others have questions as well. Now,
I was going to draw out for people's distinction of that, but I'm slightly disappointed you didn't print off the one with the pictures in it of our white paper. But
yeah. Yes, I haven't got a colour printer at home. Okay. Oh, lovely, Mary. Lovely. There we go. Now, first question. Standard method, it's what everybody's talking about. It was in the press today. A reference to it being Stalinist, I noticed, although I thought Planning Magazine did a good take on looking at what other ministers, when other ministers had used that phrase as well, just to give a bit of balance. But this is a consultation. What is it really that you're most interested in terms of potentially changing the formula? You know, you may not change it, but if you do, what are the areas that you want people to help you with in their responses?
That's a really helpful question, Chris. So we've got the current standard method we introduced a couple of years ago to cut out a lot of the delay in the process and the argument about what the number was, and try and get on to actually a bit more of a serious conversation about what it would take to meet those numbers, notwithstanding the current policy framework within which it operates. But we've got two problems with the standard method at the moment. The first is that it's reliant on some very old household projections, which actually now do mean that the standard method is not generating something which is consistent with the government's ambitions to create a housing market that supports delivery of 300,000 homes a year. So we think we've got to do something about that. It's producing, you know, and we'll get on to whether we've got a proposal out there which is producing its own distributional effects. The current standard method, because of the way in which the household projections have moved, is producing some strange distributional effects of their own, which are creating some real problems for local authorities as they try and do the planning. So I think we've got to do something about it. The question is what? And what I'm really interested in is getting people's views on how can we come up with a better methodology.
Okay, and in terms of obviously what's in the press, we've seen the backlash from the shires, as it were. would it be fair to say that there is clearly, given the political reaction, there clearly is the potential to change the version that you have gone to consultation on?
So absolutely, and in fact, this audience would haul me up if I said there was no possibility of changing something that we were consulting on. What my minister said, and worth repeating this, is we have three objectives for our new methodology. First is to deliver something which is consistent with the market that supports 300,000 homes a year. Second, to do so predominantly in urban areas where you've got an existing infrastructure, and that minimises the infrastructure burden and it minimises the burden on the countryside. And third, to do so where the market says you need to build those homes. And we're trying to come up with a methodology that does that. We've put a methodology that's out there which does that. I think it's consistent with all those. But I think people have rightly said that you can do better than that. And so I'm being quite clear that we are listening. My minister has said we are listening. The methodology is not set in stone. The bit I'd encourage people is less to point out the iniquities of our proposal than help us to come up with a better methodology. One of the things we've done in the methodology is put a bit more weight to existing housing stock. And one of the questions we are thinking about is, have we given the right balance between stock and household projections?
Okay, that's really helpful to help people focus on the key issues. Next, it's quite clear from the changes document that you are looking to support small and medium-sized builders. No question about that. But the price for doing that appears to be a fairly generous approach to exempting them from the delivery of affordable housing. So I suppose the question really is that an indication of how important the sector is, that you're willing to free them from that? And to what extent have you recognised that that will remove a lot of market-led affordable housing delivery?
So I think it's less about small builders. It's in recognition of the position that the economy is in. And you guys and many of those on listening to this will be aware of the problems that the economy is facing at the moment and the problems of the construction sector at this time. And our judgment is it's better to have a smaller percentage of a large number sometimes than to try and pretend that you're having a large number of a very small, large percentage of a small number. And that's why we've proposed this at this time to offer a bit of help to the small builders. We're consulting on that. I'm interested in views on that. There's different views for different parts of the country. We've already sort of asked about some separate arrangements for rural areas, but I think it's a good question. I'm interested in what is the right level of this, but I think it's really important that we all understand some of the economic challenges that particularly parts of the country are going to face over the next year or so, and the importance of actually acting to support those now rather than waiting.
Okay, so when you say the right level, you mean what might be the threshold at which affordable housing kicks in? And okay, all right. And to be fair, that your minister has, as Sasha highlighted last week, dedicated a very significant amount of public money to affordable housing through public subsidies. So, I can see how those might work together. Okay, well, let's move to the white paper. It would be right to say that it is a big canvas. It doesn't have all the answers. First question, though, is, does the government, why does the government think we need a new system, and why does it think it's going to be better? In broad terms, why? Why such a big change?
So, how long have you got? We could occupy the rest of this session with such a good question as that. But so just for those who haven't spotted, we're consulting on this until the 29th of October. Get your responses in. Really important for us to hear views on that. And I think there's a really important paragraph at the front of the white paper, and I think it's one I even may have had some role in drafting, but probably a very small part, which is about actually what the objectives of the reform are. And what we set out there is three outcome objectives and three process objectives. The outcome objectives are to get, for a reform planning system, to get more homes built, and we're absolutely clear about that. We've also been clear that what we want is to be delivering better quality of development. And if you the sense of the quality of development under the current planning system is a real concern in communities that I end up speaking to. And the final bit is the planning system at the moment is great at protecting the environment, but our aspirations are higher in terms of supporting our ambitions on climate change and actually delivering higher standards for biodiversity. And those three objectives about more homes, about biodiversity, and brain freeze at the moment on quality of development are really central to it. We also set out three other tests for it, which are procedural ones. So can we make planning decisions and process of entering planning to getting on site quicker? Can we make it more certain? And this links, Chris, to your point about predictability for small builders. The English planning system now is relatively discretionary by international standards. I hesitate making those comments in front of such a learned group of this, but there are other systems across the world which have much more certainty for communities and developers that we think we can build more of that into English planning. And then the sixth bit is more of a continue, which is we want to maintain proper democratic oversight of planning by the local communities. And I think those are the objectives. It's for the process to judge whether we're meeting those objectives. But those are the challenges we've set ourselves and what we're trying to achieve. And I've knocked the lights out in Chris's office.
You have. That was a long answer, so so I haven't moved. Look, Mary raised this point with Joanna last week about the duty to cooperate. That's on the way out. The replacement isn't there. My own view, for what it's worth, is we probably need to move to county planning. Regional strategies and regional planning probably quite difficult for this government, but there isn't actually a solution in the white paper to this, as Mary pointed out. So to what extent do you want people to suggest in their responses to the white paper what that solution to replace the duty to cooperate should be?
So really good to hear ideas. I think the question I always get is sort of come up with some practical solutions that really work in this space, rather than sort of theoretical ones that are just not going to work in the real world there. And I think and I often say this on duty to cooperate. It's really something which is tripping up local authorities at the moment. They're putting a lot of work in, but actually its result in terms of additional quality of planning is really tricky to see that that's actually delivering outputs there. So, but definitely good to hear solutions, but always keep them practical and deliverable ones, and not sort of magic wand ones.
Okay, big issue with the white paper, standard method with constraints in it. Okay, that's got a lot of people scratching their heads. It's got a lot of consultants already thinking about how to do that. People looking at constraints, looking at how that would work. How, again, are you looking for people to assist you in that consultation on the standard method with constraints in it?
So I think probably this is one for further consultation and discussion into next year. But some outline ideas would be really helpful. We are very open-minded. We've said nothing about how this will work at the moment. What about the methodology, precise policy framework, and how this would work? Ideas of areas which we ought to be taking into account would be really helpful at this stage.
Okay, final question from me. 5-year land supply, something of a hobby horse for me. The suggestion is it's going, really. I mean, it has been a really good disciplinary effect on authorities, and some of them do need that discipline. We've had it mostly for 40 years with a small period where it was removed and then brought back in again. Is it really on its way out?
So what we said in the white paper is that if you can get a completely new style local plan in place, then we probably don't need the 5-year land supply test for that. Which, whether we retain it for those who haven't got plans yet in place, that's an interesting question. I think that'd be an area worth exploring some thoughts about. But yes, it has been effective in delivering housing, and we've said in the white paper that we're really keen on understanding what are the balance of incentives we need to get new style plans in place. And it may be that we need to maintain the 5-year land supply. But you know, don't underestimate how grisly the 5-year land supply test is, which apply for local authorities, which are sometimes doing actually the right thing, that they've got a plan in place and have allocated lots of sites, and things fall out through reasons not in their control. So I think there is a good case for getting rid of it, for where the local authorities have got a new style plan which allocates clear land as we planned.
Okay, well, there was a dip into the toe into the water with the sort of 1 year protection in the current version. So what you're really talking about is potentially expanding that. But if those authorities don't get on with the plan, they might still find this as a stick.
So we haven't, you know, what are all the range of incentives and sticks? As you know, local authorities are very different in different places, and 5-year land supply has been very effective incentive for some authorities, much less so for others. You know, if you're a very urban authority, actually 5-year land supply tests aren't really a really strong incentive. The other bit I would also keep on sort of talking about is we're talking about the sanctions here. There needs to be proper carrots as well in that process as well. Okay, over to Mary, your question.
My question is really about infrastructure, and how, please, is infrastructure to work for plan-led development? And I would just want to distinguish between potentially very large new settlements, where potentially perhaps a DCO process could be used so that the private sector effectively takes control of providing the infrastructure. That's one possibility, is it not? But how does, in the plan-led system, the infrastructure work if there's no duty to cooperate is one of my points, really. And how are you going to fund infrastructure? It seems to me that the whole issue about infrastructure is resource. It's a resource issue. Do the local authorities have the skill set to identify the infrastructure? Are the infrastructure providers really focused on helping local authorities in a plan-led system? And how is the government going to actually distribute funds? Might you, for example, reward councils with local plans by directing infrastructure funding towards them?
Mary, I think that's a question nearly as long as some of my answers, which is not really is reflecting well on me. There's a lot in there, and I think this is an area which we didn't properly cover in all elements in the white paper. The bit I'd sort of say is what people can do in really helping us is help us fill in the space on this one. It is an area we haven't set down. The bit I would say is that there's not really a lot of evidence that I've seen that the current duty to cooperate is actually solving this problem. So I don't feel that I'm junking a system that is working well. I like your idea that we've put this in the white paper about sort of a bit more about could we bring some new settlements, very large development through the DCO regime, which I think is an interesting idea. I've heard pros and cons on that, and I welcome views on that.
Okay, next we go to Paul. Your question?
Yes, Simon. I'm just going to put a question from the audience, which I know you won't answer. Could Simon provide an insight into the progress on discussions between MHCLG and the GLA in relation to the new London plan, and comment on the future of the London plan in the context of the white paper? To which I think the answer is no comment. And then I'll ask you my other question.
I'll say we're working very closely with GLA and talking regularly. Something I want to bring to a conclusion, but there's a lot of process that has to go through on this.
I'll ask my real question now, which is the white paper, Pillar 1, which is local plan reforms, has a large number of matters like policies which are generalised policies that can be used across the country, like the soundness test, that could be introduced without the requirement for legislation, but could involve changes to NPPF and or PPG, and could therefore be introduced earlier. Is there an intention potentially to introduce the white paper reforms in a staged manner, or is it just going to be one big fireworks event in 2 or 3 years' time?
So it's a really good question, and the honest answer is we haven't got a sort of detailed implementation plan at the moment. We are working out what people's views are on that. But you're absolutely right in your first bit. There's quite sort of major surgery to planning law required for some elements of this. Not all of it, as you rightly say, but some of it. And so I think we need to work that out. There may be a case for bringing forward some bits of it earlier. But I think the bit I want to encourage people to do is let's think about which bits you could do through primary legislation, regulations, policy, guidance. I think the key thing is, and it picks up some of the comments elsewhere, is look at this from the point of view of a community. No point if the community gets all the pain through early and then the benefits happen later. It needs to be a consistent package for the community.
Okay. Charlie?
Two questions for me, my own and then the audience one. I'll start with mine because it really picks up where Paul's left off. That for those of us who got the paragraph numbers version rather than the pretty pictures, the actual white paper, as the colourful one, talks about, at paragraph 2.46, it talks about pilots for the new digital approach to plan making, those pilots involving selected local authorities and prop tech companies. And my question for you, Simon, was this, that given the fundamental importance and centrality of the new digital approach to the whole local plan process in future, and given the need to evaluate the pilots before the new regime commences, what are the anticipated timescales for the pilots and what will they involve?
So this is now where we're already working quite a lot with local government, our local digital colleagues, and if you follow MHCLG Local Digital on Twitter, you'll hear a lot about this, are already working with a number of local authorities on developing this. The way you develop modern digital is not the way when I built IT systems in the past, where you sort of do it all in a room and then launch it onto the world. You develop it much more agile methodologies and consultation. You start doing user-centered work. A lot of that is happening already. It's really exciting stuff, actually. And that's why I think it's a really important area. I'm glad you've drawn it out, Charlie, because it's one of the bits I think is most important in the white paper and is actually probably had least attention so far.
Yeah, no, that occurred to me. And actually, just following up, I mean, will you publish a report on the outcome of the pilot? Will it be something in the public domain in due course, do you think?
It's not one of those where you disappear into a hole for 6 months and then come up with a report. It's much more interactive, and it's all out there and happening as we speak. I can't remember when we last did one, but they're coming out on the tweets come out regularly.
Well, I will follow. I'm not on Twitter, but I'll keep an eye on it. The audience question is this, and here's a question I've heard before. What 3 words do you associate most with the planning system in England?
Yeah, and to which I'm going to, at the risk of sounding like I've learned from a minister, I'm not going to answer that one. But I think the bit I would encourage people is to actually engage with real people and get what they think are the 3 words, because what I think of them is neither here nor there. There's some really interesting stuff. There's some really good work that was quoted in the Building Better, Building Beautiful Commission report, where Civic Voice did some work on that, and it did highlight the lack of trust that people have in planning in England. And that's one of the things that I was most struck by, and I think is one of the most useful facts to bring into this discussion.
I mean this the right way, Simon. That's one of the most elegant non-answers I've ever heard.
Sasha?
Thank you, Chris. Simon, what I want to ask you about is, obviously anyone who reads the white paper can see the primacy that will be given to the development plan process. And what concerns me is how can you ensure that the process, when it stays at the earliest stages within the local authority, that the process of allocation is accountable and transparent? And second of all, the process of examination, when those not allocated can properly have a crack at arguing that actually the conclusions in the emerging plan are not correct. What work have you done to address those 2 issues?
So I think they're 2 really good areas. So, and with the, I don't want to sort of repeat what the eminent Christopher Kakowski said on the but a whole load of the reforms to making plans simpler, more visual, more transparent, more rules-based, more digitally available, was designed to achieve exactly your first point there about much more transparency of what's in plans. It's really tough if you're a community to work out what is in page 483 of a long PDF file. the idea of getting plans shorter and more transparent should enable much more accountability and visibility of that. I think you're right though on the second bit, which is a good area for people to get some thinking on. I suspect it may be more for next year rather than this year, is on a proper examination process. I think this is absolutely clear. What we've proposed in this is quite substantial reforms to the examination process in terms of talking about a single sustainable development test, new test of soundness. This is quite big stuff. It's commitment to having a proper examination process, but how to do that, how to get that right, and what are the right questions for planning inspectors to analyse, particularly in a world where we might be having binding versions of housing need. I think those are really good questions for discussion. Definitely what we want to have in there, but precisely how that works, one for the next stage.
Thank you very much indeed. So I've got one final question. Everybody asking, white paper, timescale, obviously very difficult. Current changes, standard method 2. Is there a timescale on that?
So I'd like to do it as soon as possible, but I don't have a specific timetable in mind. It'd be great to get a plan out as soon as possible. But I think the tone of some of this discussion and some of the other ones I've been in is it's better to get it right than rush it and get it too quickly and it doesn't stick. So I think that's a reasonable bit of feedback I've heard.
Charlie?
Thanks very much, Chris. Thanks, Simon. That was really fascinating insight. Champion of the week next, which I'm going to do. And my champion this week is an inspector, a very experienced inspector, known to a lot of people, Inspector David Richards. And he issued a decision in July, but only came to my attention actually last few days in relation to a self or custom build housing scheme in Wychavon. Having noted that the South Worcestershire Development Plan, which applies to Wychavon, contained no policies in relation to self or custom build, in contrast to paragraph 61 of the framework and the Self Build Act, which requires self and custom builds to be taken into account in plan making, he held that tilted balance was engaged. And he said this, I'm not going to share the screen because I'll screw it up, but he said at paragraph 51, there's no dispute the council can demonstrate a 5-year supply. But the development plan's out of date in respect to self-build. There's no reference to self-build housing within the policy SWDP2. SWDP14 addresses the mix and type of market housing, but doesn't say anything substantive about self-build. In view of the importance attached to provision for self-build housing in the MPPF and PPG, I don't accept the Council's view it should be treated simply as a component of general market housing. The tilted balance is therefore engaged. Why do I make him champion of the week for that? Well, it's a paradigm application, in my view, of the tilted balance. A default mechanism where the local plan doesn't do what it should be doing in relation to the kind of development in question. That's my view as to what the tilted balance is all about. That default mechanism. By no means have all court decisions and indeed, have all appeal decisions and indeed court judgments approached the tilted balance with such crispness and clarity, having regard to what I suggest is its real purpose. So hats off to David for doing so. I hope he's not challenged. If he is, I very much hope that decision is emphatically endorsed by the courts because it's a brilliant decision. Nudge of the week, Mary.
Nudge of the week is to you all out there to watch out, because I had a rather unfortunate experience last Friday when for the second time PINS pulls a hearing that I was going to have. And that's because I think their internal website system was not keeping up with what they were agreeing between the main parties. So my advice to everybody out there with an appeal is to make sure that if you've agreed a digital hearing or a digital inquiry, that the PINS website is up to date. Otherwise, you're, like me, going to find yourself being postponed at the last minute.
Thanks, Gary. A splurge of questions about where people can find that self-build decision. Feel free to email me or Rebecca at info@havewegotplanningusforyou.com and I'll send it to you. But the reference, it's the 23rd of July. It's called Corner Mead, Corner MEAD. I won't read out the numerical reference because it'll sound...
Charlie, shout out to Jack Smythe and Neil Pierce who did that case. That site is just around the corner from my mum, and I wonder whether we should take one of the plots and build our own. Have we got planning news for you? Self-build house.
Absolutely.
Not living with you, Chris. It's not happening.
I'll live with you, Chris.
Yeah, thank you.
I'm telling you. Chris had to tree. Great. Well, that brings us to a close today. First and foremost, thank you all, for you dear viewers, for watching us, and indeed YouTube viewers in future for watching us when you come to watch us on YouTube. And massive thanks to Simon for putting up with us not once but twice, a second time, and for some really, really useful insight, which I'm sure everybody will have found extremely helpful. Don't forget, people, to make your consultation responses. That's what the consultation is there for, and there's another encouragement from Simon today to do that. We will be back at the same time, same places, or certainly same screens, next Thursday, the 24th of September, 5 p.m, with another very special guest who we have lined up. We'll tell you about who that is next week. Please do sign up to our mailing list if you haven't already, info@havewegotplanningnews4you.com to get our updates. Don't forget your charity donation, and as always, please do let us know any suggestions you might have for what we might cover, because we would love to hear them. Until then, enjoy the weather, have a lovely weekend, and we'll see you next week. Good night.
Bye.
Bye.
Bye. Auf Wiedersehen.